That is the end of the victim's mother's testimony. Let's welcome defense attorney, former head prosecutor Bob Bianchi. And Bob, I feel like I've been cheating because I've been watching you on one of my monitors throughout this testimony and your reactions to it and reacting like you are now and shaking your head. Tell us, please, why? What stood out to you?
I'm sorry, Judge. I got the giggles now. Okay, so and your producer made a comment too. No, it's just the interpretation, the lack of skill with the lawyers. Look, it's hard. Don't get me wrong. The woman speaks English to a certain degree. She's answering the question. She's anticipating the answers in English. The guy's he's talking the interpreter to her and him to her, and it's not being translated to the court. And they're asking wildly complex questions when you're having an interpreter interpret, and the nature of the questions and the subjectiveness of it. Look, when you got a witness like this on the stand, if you're the prosecutor and you're trying to get information out from her, you got to be clean, you got to be crisp, you got to make sure that she understands the cadence. Wait till the question is answered. The interpreter will then interpret it. You will then speak to the interpreter. The interpreter will then speak to the court. You can't have a combination of activities going on. And really, the court should have stepped in at a certain point in time and said, look, a little leading is okay. It was wildly speculative questions. So I just felt from the standpoint of having been a person who, by the way, has had many interpreters, it's lugging. It's like reminds me of riding a motorcycle. Like it's going to lug the testimony. So you've got to be really clean and crisp and get that cadence going. So that's what you were watching me doing, because I don't know how you felt. I wasn't even listening to the answers. I was watching the antics of the interpretation.
And I think jurors are potentially doing exactly what you were doing, exactly what I was thinking, which is you've got to be so clean and crisp in terms of those logistics. It's not a slight on any person involved in those logistics, but just the way the attorney asked those questions. And so the jury may also be laughing, Bob.
Yeah, Judge, it's a typical thing when I train lawyers, and me and you have actually been together training lawyers on panels. It's not about just spitting out questions and getting robotic answers back. You've got to understand there's 12 people that are going to be making a decision on the fate of another human being, and they have to understand what it is. And a lot of times lawyers have this cadence where they just want to spit it all out and at least feel like I've accomplished something. You've got to be bigger than that. And even on cross-examination, it doesn't make a difference what lawyer it is. You have to make sure the jury is understanding the level of interpretation. And what was happening there too, and I've seen this happen, I had this literally happen one time, where you're giving a long question and then the person says like one word. I don't know Japanese or Chinese or any other language other than Italian. So when they say one word though, and the person's now giving a long answer back in court, that's not right. You have to know when to say, Judge, can we clear the jury out? Can you make sure their interpreter, because the interpreter was making mistakes too. The interpreter was breaking the rule by having colloquy with the witness that was outside the record, if you get my point. It was just really poorly done.
Yeah, because it has to be clear on the record for appellate purposes, because the whole point of the cross was to impeach her, to have her say she told police there was one chair turned over. Now she says there was two. She said the dogs woke her up at 2 a.m. when she talked to law enforcement 2 years ago. Now she's saying it was 3 a.m. That was the point, but I think it got lost. All right, Bob, unfortunately, we do have to squeeze in a break. Stand by, though. We'll get back with you. When we come back, we're going to switch gears. We're going to head to Tennessee for closing arguments in the Broke My Heart murder trial against Latoshia Daniels, the woman accused of killing the pastor she was having an affair with. Stay with us. We'll be right back.
Tonight on Closing Arguments, a 10-year-old arraigned on attempted murder and rape charges after a brutal attack on a little girl. We'll bring you the latest in this tragic case.
Closing Arguments with Vinnie Politan, tonight at 8/7 Central, only on Court TV. Next week.
Get your day started with true crime and trial drama. Each morning, we'll take you inside the country's biggest cases before we take you inside the courtroom.
Opening statements with Julie Grant. Mornings at 8/7 Central on Court TV.
We are switching gears now to Tennessee, where we are nearing the end of the Broke My Heart murder trial against Latoshia Daniels. The defendant is charged with murder for shooting and killing Brodus Perry and injuring his wife, Tabitha. Daniels does not deny shooting Perry. She tearfully testified yesterday in her own defense that the married pastor manipulated her into an affair and that she initially bought the gun to kill herself after he broke up with her. Before we go into court for closing arguments, here is Court TV anchor Julia Janae with more on the background of the case.
Not only have we experienced the death of Brodus Perry to violence.
On April 4th, 2019, police respond to a shooting about 30 minutes east of Memphis. Once they arrived, they found Pastor Brodus Perry with several gunshot wounds and his wife Tabitha shot in the left shoulder.
The rumors swelling around his murder leave us shocked and shaken.
According to the police affidavit, Tabitha let former acquaintance Latoshia Daniels into the apartment. Once Perry arrived home, he and Daniels spoke for several minutes. As she was leaving, she pulled out a handgun and began shooting, hitting Perry 5 times and telling him, quote, "You broke my heart."
She also shot Tabitha Perry as she was kneeling beside her husband, trying to get him to quit, trying to help him, and trying to get the defendant to quit shooting. She was still on the scene with the gun when the police department arrived.
Police shot Daniels, and she was taken to the hospital for her injuries, where she attempted to get away from police. She faces charges of first-degree murder, attempted first-degree murder, resisting arrest, and assaulting a police officer. The defense claims Daniels was in an abusive open relationship with Brodus Perry and went to the home to try and fix the relationship after he broke up with her.
This was a moment that broke between Latoshia and Brodus, but it was not a moment of cool, calm judgment. It is not what that night was supposed to be. That night was supposed to be a start.
Surviving victim and wife Tabitha testified at trial that she was completely unaware of an affair between her husband and Daniels.
Let's go into court together now. The state is now giving its closing argument to the jury.
You broke me. I felt used. He broke up with me in a disappearing text message. Who does that to someone that they love? I wanted him to feel the pain that I felt. These are the words of the defendant, Latoshia Daniels. And earlier this week, we told you that you would hear a lot of testimony. You would see some pictures, you would see some videos, but most importantly, we wanted you to pay attention. And a key part of paying attention is not getting distracted, not getting confused as to who the victim is. The victims in this case are Mr. and Mrs. Perry, not the defendant. The decisions that she made caused them to be victims. And once we're finished here today, you'll see that this case really isn't that complicated. It's kind of easy. She's charged with 3 counts: first-degree murder, criminal attempt first-degree murder, and employing a firearm during the commission of a dangerous felony. First-degree murder, and you'll see this in your jury instructions, is defined as a premeditated killing of another. 1, the state has to prove that the defendant unlawfully killed a victim. 2, the defendant must have acted intentionally. 3, the killing must be premeditated. So, what is considered unlawful? Well, what is considered unlawful killing? One example can be the defense of others or yourself. Intentional. What does it mean to be intentional? Does it seem like an accident? Does it seem like a mistake? Your jury instructions say that something is intentional if it's a person's conscious objective or desire to cause the death of another person. Number 3, premeditation. The killing has to be premeditated. And as we learned in voir dire, premeditation doesn't have to be a specific length of time. It could be 2 seconds, 2 days, 2 weeks, 2 months. There's no time frame. It just means that you had to think about your actions and you had time to reflect. That could be as simple as stepping out of your car, raising your arm, and the time it takes you to point the firearm at someone and shoot and kill them. Or in this case, it could be driving to the gun store, purchasing a gun, purchasing ammunition, leaving the gun store, driving 3 hours to Memphis to your married ex-boyfriend's house, and knocking on their door. So this week, we started off hearing from Tabitha Perry. She testified that her husband was an executive pastor in Little Rock, and later he moved to Memphis along with her for a new position at Mississippi Boulevard, a prominent church here in Memphis. She also testified that they knew the defendant. They knew her from Little Rock when he was previously working over there. And on April 4th, 2019, Mrs. Perry heard a knock at her door. When she went to her door, the defendant was standing there. Now, she thought it was odd that Ms. Daniels was standing there, but she didn't think too much of it because they had given their address out to several people at the church in Little Rock. After she let her in, Mrs. Perry and the defendant sat and talked about 20 minutes until Brodus Perry showed up. When Mr. Perry showed up, the defendant even told you that they sat and talked for a while. She even took a drink. And once she decided that it was time to go, Mrs. Perry and Mr. Perry led her out of their doorway. And as Mrs. Perry was leading her out of the doorway, she turned back and she saw the defendant reach into her coat pocket, remove a gun, and shoot Mr. Perry in his own doorway. Once she did that, Mrs. Perry looked to her neighbors for help. She tried to get help, and then when she saw her husband lying on the ground, she went to go help him. She pleaded with the defendant, "Why are you doing this? Why is this happening? Please stop." Well, not only did the defendant not stop, she shot Mrs. Perry. And not only did she shoot Mrs. Perry, she reloaded her gun. After Mrs. Perry, we heard from Detective Roberts. He testified that the very weapon that was used to shoot Mr. and Mrs. Perry was purchased hours prior to this incident. He testified that the defendant purchased that firearm at a gun store at around 4:30 that same day in Sherman, Arkansas. Detective Roberts told us that he spoke to Ray Palladino, the general manager of that sporting goods store. From Mr. Palladino, he received the surveillance footage. And that surveillance footage showed the defendant coming in, purchasing a gun, purchasing ammunition, and leaving. Mr. Palladino also provided Detective Roberts with a receipt. That receipt had the defendant's first and last name on it. It had the serial number of the Ruger handgun that she purchased and the last 4 digits of her credit card. It's the same credit card that Detective Roberts discovered in the defendant's vehicle when he searched it. We also heard from Dr. Curry. Now, Dr. Curry testified that she performed Mr. Perry's autopsy. She testified that the cause of death was multiple gunshot wounds and the manner of death was homicide. She testified to recovering the bullets, placing them in an envelope, initialing and dating them, and leaving them to be picked up. But Dr. Curry isn't the only doctor we heard from. Defense put on Dr. Bidding. Dr. Bidding was hired by the defendant and her team. And you heard her. She testified that she has testified for more defendants than she has prosecution. And ladies and gentlemen, think carefully about what she told you. She told you that depression and someone being suicidal does not mean that they cannot form the intent to kill someone.
Going through the different witnesses and their testimony, starting with the defendant's own words. What do you think of the closing? Let us know on social media. We'll take a break when we come back. Of course, more of the state's closing arguments in the Broke My Heart murder trial up next. Welcome back to Court TV Live. I'm Judge Ashley Willcott. Let's turn now back to Tennessee, where closing arguments are underway in the Broke My Heart murder trial. Defendant Latoshia Daniels is accused of fatally shooting her married boyfriend and injuring his wife back in April of 2019. Prosecutors say Daniels drove from her home in Arkansas to Tennessee in order to confront Perry after he broke up with her that day. Let's get you back into court now for the rest of the state's closing argument.
Also told you that she didn't even offer an opinion as to the defendant's mental state at the time of the offense. So what do we need? We need an unlawful killing, intent, premeditation. Unlawful killing. Well, there was no self-defense claim, and the only other firearm found in the residence, found in the crime scene, was in a box under a nightstand in a completely separate room. Intent. I wanted him to feel the pain that I felt. He broke my heart. You heard that from the defendant herself. Premeditation. We'll take your pick. Whether it's the drive to the gun store, the time it took to purchase, choose a firearm and ammunition, the time it took to drive 3 hours to Memphis to her ex-boyfriend's house, or the 20-minute conversation she had when she finally went up to their apartment. Criminal attempt first-degree murder. So in your jury instructions, you'll see what's on the screen right here. And that's a lot of words. But the judge is giving you the law, and the best way that I can describe it is that the defendant must have an intent to commit first-degree murder. But they fell short for some reason. The act wasn't complete. And that's how you have criminal attempt first-degree murder. We heard from Tabitha Perry, and she testified that she was shot in the shoulder. After the incident, she was transported to the hospital, and the doctors left the bullet inside of her. It wasn't until later that she had to get it surgically removed. It was causing her extreme pain, and by the time that she got it removed, it was poking out of her back. And even today, 6 years later, she is still suffering from pain from that incident. Now let's talk about transfer of intent. You heard in your jury instructions that sometimes when you intend to kill one person and you don't kill that person but you kill another person, that is how the transfer intent happens. Tabitha Perry testified that when she spoke to the police, she told them that she didn't even believe that the defendant meant to hurt her. But that's okay. Because you don't have to actually hit your intended target to be charged and convicted of criminal attempt first-degree murder. As long as you had the intent to kill one person, it doesn't matter that you accidentally shot or you actually shot someone else. Your intent is still there. The only thing that's different is the person that got hurt. Employing a firearm during a dangerous felony. So on the screen here, it says that any person who employs a firearm during the commission of a dangerous felony is guilty of a crime. The state has to prove that 1, that the defendant employed a firearm. 2, the employment was during the commission of or attempt to commit criminal attempt first-degree murder against the alleged victim, Tabitha Perry. And 3, that the defendant acted intentionally, knowing, or recklessly. In addition to Mrs. Perry's testimony, we heard from Captain Draper, Officer McLean, and Special Agent Broxane. Draper testified that he and McLean were a few of the officers that responded to the crime scene on the offense day. And when he got there, he witnessed the defendant holding a firearm. She refused to comply with orders. Captain Draper testified to the non-lethal force that was used to unarm her. Officer McLean testified to securing and clearing the weapon that the defendant had in her possession. He noticed that there was nothing in the chamber, but yet there was a magazine in the gun. Special Agent Sane testified to the ballistics. He examined the Ruger, the casings, and the bullets from the medical examiner. He determined that all the cartridge cases and the bullets had been fired from that same handgun that was recovered off of the defendant. And now we're back at the beginning. You broke my heart. So I'm going to purchase a firearm. You broke my heart. So I'm going to purchase ammunition. You broke my heart. So I'm going to take that gun and the ammunition and drive 3 hours away to your home. You broke my heart. So I'm going to knock on your door. You broke my heart. I'm going to sit there and talk with you and your wife for about 20 minutes. You broke my heart. So I decide to leave. You broke my heart. So I'm going to shoot you and kill you in your doorway, and along the way shoot your wife. But it's okay, because you broke my heart. Decision after decision after decision. Ladies and gentlemen, if a broken heart was an excuse or a defense to murder, I wouldn't have a job. The standard of proof in this case is beyond a reasonable doubt. Not 100% certainty, not beyond all doubt, not beyond a shadow of a doubt. What's required is certainty that lets you rest easy at night. And now it's your turn. After you consider all of the evidence and apply the law that the judge has given you and use your common sense, the state is confident that your verdict will be guilty as charged. Don't let a broken heart distract you from the human life that was lost. Thank you.
May we approach?
Yes.
Still with us, defense attorney and former head prosecutor Bob Bianchi. All right, Bob, what do you think overall of the closing argument? You broke my heart. I'm going to buy a gun, drive 3 hours, walk in, talk, broke my heart, broke my heart. That's what I thought, too. Tell us more. I was very compelled.
I think the prosecutor was amazing. I as a trial lawyer who's pretty good myself, I was saying to myself, could I pull this off? She did a great job with the law, explaining the law, using the law to her advantage, bringing it down to common terms to a jury in easily understood language. What I really loved about her was that she was also spicing in some great things. She took the most important part of the case. You broke my heart. And I always say this, she did the principle, Judge, you may even have heard me say this before, looping. And she kept using it over and over again in a very colloquial way that would resonate with the jury to over and over again emphasize the motive. And while at the same time, in great detail, showing all the steps it took for her, the defendant, along the way to show that this was not passion and overwhelming of reason, but rather a purposeful attempt to kill, in fact did kill, and attempted murder with the wife because you broke my heart. I gotta tell you, I think this is one of the cleanest, best jury impactful closing statements I've seen in a murder trial in all the years that I've covered cases on multiple networks, Judge. I thought it was phenomenal.
And that is such high praise coming from you. And I will say this, she didn't go too long. I was afraid at first she'd get into too much of the testimony. She didn't. It was a good length. And then this line is what stuck with me, and then we need to take a break. If a broken heart was an excuse or a defense, I wouldn't have a job. I think that summed it all up, right? All right, Bob, stand by. We are going to hear the defense's closing argument. That's next in the Broke My Heart murder trial.